What is an affidavit of heirship? An affidavit of heirship is a legal document used in some states to establish the legal heirs of a person who dies without a will. The laws surrounding heirship, intestacy, and probate can be complicated and confusing to navigate, especially while you're mourning the loss of a loved one. Consulting an estate attorney is key to understanding whether these forms may be used or a probate will be needed. What is the meaning of heirship? Heirship is the legal right to receive money, property, or possessions from a person who has died intestate. The word intestate means that the deceased person, who is sometimes called the decedent, died without a will detailing who their personal representative or executor is, or how that person is to distribute the estate assets. In these situations, state intestacy laws determine who has priority to be appointed executor and to whom the property is going to be distributed. Heirs are usually children, descendants, or other close or sometimes distant relatives of that decedent. Spouses usually aren't classified as legal heirs since they're entitled to receive property under marital or community property laws. Heirs are distinct from beneficiaries, who are legally entitled to receive the decedent's property because the decedent designated them as an intended recipient of some assets under a will or trust. Obviously, it's not unusual that beneficiaries are usually heirs as well. What is an affidavit of heirship? An affidavit of heirship is a sworn statement that heirs can use in some states to establish property ownership when the decedent dies intestate. Affidavits of heirship are generally used when the decedent only left real property, personal property, or had a small estate. However, some states, like California, use a small estate affidavit rather than an affidavit of heirship, and even then, only in limited circumstances. Generally, whenever someone dies without a will and leaves property behind, their heirs may need to open a probate so that title to that property can be passed on to them. However, in some instances, heirs can avoid the time and expense of probate by using an affidavit of heirship, making it a common and less expensive way to handle intestate estates. If the following statements are all true, then an affidavit of heirship may be a good option for processing an intestate estate. 1. The decedent died without a will or trust, meaning they're intestate. 2. You can identify yourself as the decedent's lawful heir. 3. You want to take possession of the decedent's estate without going through probate. 4. All of the decedent's heirs have agreed on how to distribute the estate. 5. There's a third party who can verify your right to the decedent's estate. It's essential to keep in mind that heirs cannot use affidavits of heirship in every situation, and state laws differ on how and when people can use them. It's very common for heirs to seek an experienced estate attorney's advice when determining the best way to deal with an intestacy situation. How do I file an affidavit of heirship? An affidavit of heirship is a list of all known information about the decedent's family history and relationships. Filling out an affidavit of heirship is similar to creating a family tree for the decedent. An heirship affidavit must include the following information. 1. The decedent's name and address. 2. Their date and place of death. 3. Their marital history. 4. Their family members, including children, siblings, parents, nieces, and nephews. Can an affidavit of heirship be contested? Yeah, absolutely. Unlike a judicial determination that conclusively determines a decedent's heirs, usually from a probate court, an affidavit of heirship only creates a presumption that the facts contained in it are correct. Therefore, the family lineage established in an affidavit of heirship can be contested. If an heir has been omitted from the affidavit of heirship, their legal rights to inherit the decedent's property aren't affected at all. Instead, the forgotten heir can present evidence to establish their heirship and overrule the affidavit, either entirely or partially. Who can contest or dispute an affidavit of heirship? Most commonly, an omitted heir will contest or dispute an affidavit of heirship, typically by filing a correction affidavit, otherwise presenting evidence of their relationship to the decedent, or initiating court proceedings. For example, suppose the affidavit of heirship filed by a decedent's children from a second marriage does not include a child from a first marriage. In that case, the excluded child could provide a birth certificate and other evidence to establish their relationship to the decedent and their right to inherit. When should I contact an estate attorney? If a family member or loved one has died intestate, you should contact an estate attorney to see if a probate or a probate alternative like an affidavit of heirship or small estate affidavit is available. An experienced estate lawyer knows how to help grieving family members decide the best course of action to take when a loved one passes. Have questions? We protect people like you every day. Give us a call, shoot us an email. The consultation is always free. Thanks for watching.